good point, Joy.
Since we were talking about assessments and calculating growth, we are going to take one more item out of order and put the Indiana Growth Model next, and then we will proceed down our agenda as written. I believe Debbie and Claire Fidian Green, are you presenting? I know that each of you, it looks like, want to speak. The board has a memo regarding this.
Good morning, board, and again, thank you for having me today. My name is Debbie Daly. I'm the Director of Accountability with the Indiana Department of Education. Obviously, Claire Fidian Green is joining me as well. We want to discuss a memo that was sent to you with your packet of State Board of Ed materials. Claire, do you want to take the lead on this and I'll fill in, or would you like me to go through it? Go ahead. Okay, perfect. As we've shared with the board before, there were some concerns about the measure of growth to be used in the accountability system in the 2014-15 school year. In 2014-15, due to the assessment transition, there were concerns that the component of growth that we currently use on the A through F system would not be available. Now keep in mind that form of growth is actually 1 year projected targets. What that means is a prior year student growth percentile analysis is calculated. The 1 year projected target from that analysis is then compared to the current year scale score. With the change of assessment, what would happen is that scale score for the target would not be applicable to the new scale being used on the new assessment. Therefore, we reached out to Dr. Damian Benebetter excuse me, and had him analyze the different forms of growth. The Department of Ed put together about five options for growth, what we could look at, or how we could potentially measure growth again in this transition year. Damian Benebetter again was able to provide analysis for each of those 5 options. The department, in collaboration with CECI, worked together to step through each of those options to provide a recommendation for which option we should use going forward. As you read through these options, we all agreed to option 1.II, which means actually using those projected targets, 1 year projected targets, along with an equipercentile concordance table to basically translate the previous scale score to the scale score on the new assessment. So in your memo, you'll see that therefore CECI and DOE staff jointly recommend that the board approve option 1.II, growth calculation recommended by Damian for use in 2014-15.
And I will just add that, as you heard Dr. Derek Briggs just a moment ago, and if you have follow-up questions, I encourage you to call him up. We asked him to take a look and have another expert weigh in to see whether he agreed with Dr. Benebenter's recommendation, given the challenge of shifting to a new assessment system, and he concurred that that seemed like the best option for Indiana in 14-15.
I did want to throw in one additional note on this, and this has to do with one line that was on this memo concerning the compliance with HEA 1427. I did want to note that the department does agree that this does not have conflict with HEA 1427. However, we feel that there are other options that are more compliant with HEA 1427 and do want to evaluate those other options of growth moving forward as we start rule-making process for A through F and a new version of A through F. Does that make sense? Would you like me to elaborate on that?
Okay. Well, we're taking action on 14-15.
Correct. This is for 14-15. I
Correct.
just wanted to elaborate on that note since it was in the memo about 14-15.
Right. It's not necessarily a recommendation going forward. It's a recommendation just for 14-15. Okay. Thank you very much.
Thank you.
Roll call, please. Oh, wait. I move that we adopt, let's see. There it is. Is there a motion to approve as Indiana's growth calculation for the 2014-15 the option recommended by the department and the board staff?
So moved.
Is there a second?
Second.
Roll discussion? Roll call, please.
Quick comment.
Oh, so sorry. Was that Brad or Tony?
That is Brad. I just want
want to make a quick comment, just for clarity, and if I'm misunderstanding this, it would be great for Deb and Claire to clarify this. But I think I saw some things publicly yesterday stated that somehow this approach on option 1 violates 1427, and I wanted to emphasize the use of the individualized targets, and I'm just looking for affirmation from them that we're not simply taking student scores and simply lining them up in order to find a bell curve, that we're rather comparing that student to an individualized target, and that's the focus here for growth.
Debbie?
Sure, thank you. And Brad, this is exactly the point that I'm making concerning HEA 1427. The department does not feel that this approach is in conflict with HEA 1427. However, this concept of peer-based growth versus criterion growth is not necessarily a black and white. It's not an absolute. It's more of a gradation of compliance. And while we feel that this version targeted 1 year projected growth is not in violation of HEA 1427, we do feel that there are other options that are more compliant, that do adhere more to, are more criterion than the version that's currently being used in A through F model.
And the accountability panel is looking into that.
Correct.
Thank you, Brad. Roll call, please.
Yes.
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 Yes. Dr. Oliver? He said yes. Okay, he said yes.
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 Yes. Motion approved. We're on to the next item of new business, which is the determination of CASA exam scores. You had a presentation at the last board meeting, and we presented you with 4 options. And I believe there was some consensus, and it is the department's recommendation, that we go with option 2. And Risa, if you would briefly describe what option 2 is.
Option 2 would be to adopt the panel recommended cut scores for the 3 CASA basic skills subtests. That would bring those scores in line with the 61 licensure content and pedagogy exams that went through score setting this year, and the board set all of those cut scores at the panel recommended level. So option 2 would be our recommendation to bring the CASA scores in line to be consistent with the panel-based cut scores.
And it also includes keeping our non-compensatory model, separating out the scores, because that seemed to be important to the board, to still see those separate scores in math and reading and language arts.
I have a question.
Yes, David?
So test takers would have to pass each component.
They have to
Each-
pass
each of the
subtest
tests.
at the passing score.
Mhm.
Okay, so last meeting we talked about getting 2 out of 3, or, but
That would
that's,
be the compensatory model, which would
Right.
be, sometimes that's called a composite score, but that's not what we're recommending. We would recommend that the test taker must pass each of the subtests at the passing score.
and the panel recommendation, has that been sent on to the testing company to be sure that it does not negatively impact validity of the test and reliability?
Well, the testing company actually
Already
conducted,
did that.
Pearson actually conducted the score setting studies for us with those panels. So they were a part of this process and did the statistical analysis for the panel.
So to approve the recommendation does not provide any negative impact on the fairness of students or the fairness of the test at all. We have psychometric data to support what we're doing.
Yes.
Any other discussion? Is there a motion to implement option 2, which is to approve the panel recommended scores for individual subtests non-compensatory model?
So moved.
Is there a second?
Second.
Any more discussion? Roll call, please. Did I miss?
No.
miss anything? Okay,
No.
sorry, Risa.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes. Yes.
Yes.
Yes. Motion approved. The next item is approval of ECA testing dates for 14-15. Michelle Walker?
Thank you, Superintendent Ritz and members of the board. The last set of dates that we're bringing for your approval this summer is related to ECAs, and those end of course assessments actually have 5 windows. You'll notice in the memo that we sent, some of those windows are split. So for example, the early winter window actually starts in December, and then there's a second portion in January, so that we can adjust to no matter what kind of schedule the school might have. The ECAs work a little bit differently. Obviously, the windows are set, and schools decide within the window whether they want to give the test online or paper pencil. For online, they select 8 days within the established window that's approved by this body. If they're giving paper pencil, it's 4 days. So the board approves the dates of the windows, and then the schools submit within the online system with our vendor Questar. They're either 4 or 8 day window for each content area. So if they're giving online, for example, for Algebra 1, English 10, and Biology 1, that's actually 3 sets of 8 days that they would have available to them. Schools also can test in each semester, one of the 2 windows in each semester. So we present these for your approval.
Yes, David?
Schools have the opportunity to administer the test either paper and pencil or via technology.
Right, so for ECAs, the board has never actually made a statement about what you want to do with regard to technology. Likely in 15, 16, and beyond, you'll want to have some policy around that.
Have we looked at whether there's significance between paper and pencil and via technology in the actual scores? Is there
So-
validity, reliability, alignment between
Yes.
both?
So we do comparability studies actually in both 3 through 8 and ECAs with regard to paper pencil versus online. That's a great question.
And the results were?
And they're comparable, so.
They are,
Yes.
when you say comparable, are they
It means that
aligned?
they're, it means that the assessment results are comparable for either of the modes, and therefore one is not an advantage over the other.
Good.
So,
Okay, thank you.
yes.
Any more questions for Michelle?
I think we
I
need
move
a
that,
motion.
I move that we approve the ECA testing dates for the 2014-15 as proposed by the department. Is there a second?
Second.
Any more discussion? Roll call, please.
Yes.
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 Yes. Yes.
Yes.
Yes.
Thank you.
Next item of business is the lead partner recommendations. I believe Teresa, Assistant Superintendent of Outreach for School Improvement, and Bob Guffin, are you presenting? And the board has the memo.
So back in June, you directed the department and board staff to get together with IPS, have a needs assessment, and bring to you a recommendation this month of a lead partner for both John Marshall and Broad Ripple Magnet High School. So we did that in June. We met together. Dr. LeGrand represented IPS. We discussed the needs. We then invited proposals from all the current lead partners. We went through those together to identify the one that would best match the needs that we determined as a group collectively. And we are bringing forward to you TNTP as our recommendation for both John Marshall and for Broad Ripple, and with the intent that they would come back in August and provide you a more detailed presentation of what that scope of work will look like once they work that out with IPS.
And it's my understanding that IPS is also recommending this as well.
Correct.
Okay.
We
thank
all
you.
agree.
All right. Any questions?
Question.
Yes, David?
Would you briefly summarize why this lead partner was selected? What are some of the characteristics that put them out in front compared to maybe some of the other partners we could have worked with.
So the two areas that we identified collectively that we wanted to improve classroom instruction, high quality classroom instruction, and then also classroom management or operational procedures at the schools. Both schools had those common needs. As we looked at the proposals from all three vendors, TNTP met the expectations we had for high quality instruction at a much deeper and higher level. So they impressed us with their scope of work proposal.
Is there a motion to approve the new teacher project as lead partner
So moved.
for Broad Ripple Magnet School and John Marshall Community High School as recommended by the department, IPS, and the board staff?
Second.
Any more discussion? Roll call, please.
Yes.
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 Yes. Yes.
Yes. Yes.
Yes.
Yes. And Dr. Farabee, the department looks forward to working with you on the contract for this. Thank you very much. Move it up now? Okay.
I just enjoy your responses, so.
So,
It's hard to do in communication.
I've had a request to deal with the notice for petition of adverse action, which is under discussion, to move it up to the agenda so that the parties that are here, can get back to where they need to go. Is there an objection to doing that and moving it forward? Okay, thank you.
Good afternoon, everyone. The parties are here. The adverse action was a matter that was brought to the attention of the department and board staff by Edison, the operator for Roosevelt and Gary.
Can you speak up and into the mic? Thanks.
Okay. The parties are present, but they... Sorry, everybody. Is that better?
Yeah.
The parties are here. They're present. They would like some more time to talk and try to work out their issues, and so they are here asking the board to allow them, if their issues aren't worked out by the next board meeting, to put them on the agenda for August. So we're asking to put this matter off until, they're asking to put it off until August. And the parties are
both councils
present.
are okay with that?
Sure. We jointly recommend that we do delay it. It was just a discussion item, and it's my understanding that the parties are here, but they are committed to resolving it on their own.
Do you need
When
a
does
motion
school
to delay it? or
Well, I think it's a removal from our agenda, but it's discussion. So I don't think it takes anything to remove the item for discussion. It would take something if it was under action, most definitely. Yeah, Sarah, did you have a comment?
I just was curious and wanting to clarify, is there any impact on the students attending this school if this is delayed for another month?
When does school start was my question.
Right.
When does school start?
I know it's in August, but I'm not sure of the exact date. Do either
It's
of you?
August 4th. That's before our next meeting.
So if I can clarify on process.
When was that date again?
Did I hear August 4th?
August 4th.
If I could, on process, this was listed for the board as a discussion item and not an action item. The procedures that were adopted by the board in May of 2012 actually has an administrative law judge who would bring to the board a recommended decision. I have already made that request for an administrative law judge, so removing this from the public agenda doesn't necessarily stop those wheels from moving. And only if we hear that an agreement has been reached would we rescind that request for an administrative law judge to bring to the board a recommended decision, hopefully by the August meeting.
And just to clarify, I think the board's all interested in expediting this so that it's not going to have harm to students. So the process outlined for the actual adverse action, is that expedited? That's the department's concern.
Sure. So the process that was adopted by the board in May of 2012 is drafted in a way of maximum time. So within 30 days, there's a possibility that someone could request an extension of up to 60 days. But it certainly doesn't necessarily put those windows in place that it would take that long. And the request has been made for the administrative law judge to expedite the process as much as possible. So given that we're talking about students in a school where the water has been shut off, I trust that the administrative law judge would have the good judgment to expedite it. And if I may say, if that decision becomes available, I would always email the board and let them know, and we could have an emergency meeting as necessary to get to it as quickly as possible.
Dan?
Chair, I like to be heard on this one. It's a good time.
Yeah, Dan, is that Tony?
I defer to Tony, he lives there.
Tony, go ahead.
I just object to us entertaining this at all, quite frankly. Part of the issue is, as it relates to the specific petition, is that Gary Community School Corporation really did not have reasonable notice to respond. I think they had maybe a weekend or so. But above and beyond that, these issues have been ongoing now for 2 years. And when similar issues, maybe including some of the issues that are being raised in the current petition, originally came up, Edison, I think, took the right approach in going to court for a resolution. Ultimately, the questions that are before us revolve around statutory interpretation and responsibilities. We can't really do that as a policy body. I mean, it's really ultimately a legal question that is at issue, number one. And number two, we have already had that approach undertaken by the petitioner, who did not avail itself initially of this adverse procedure process, but went straight to court, and I think they appropriately did so. But by them doing that initially, it puts us in a position where there may have been issues raised, because as I recall, the issues were very similar that were brought before the court. There may have been issues raised in the court and decisions made in the court that now, with what we in the legal world call collaterally estopped from being raised again. The court may have made decisions related to some of these matters that are now pretty much the final decisions. We don't have authority, though, to go and undo what the court has already ordered regarding that. And with that in mind, I think the appropriate procedure would be for either of these parties that are in dispute to go back to the court where they were and file an injunction or whatever they need to do to have these issues addressed, if in fact they can be addressed again. So I don't even think that we have the authority to issue a remedy for what's being complained about here. And ultimately, even if we do issue some type of determination as to what that statute means and what the regulations require, it's going to go to court anyway. So it's just a waste of time, and it slows the process down from getting this resolved before the next school year starts. So let these folks go back to court and figure this out. And our concern should be for the students and not for getting involved in the middle of what ultimately is a legal question and a legal dispute. Now, as it relates to the safety and environment that the students are in, I think we have other measures that we can unilaterally look into taking to resolve that. But this is a dispute we shouldn't be involved in. Thanks.
Do you have a response, Michelle?
Well, I think without addressing the substance of those, our hope is just to remove it from the discussion agenda so that the parties and their counsel could go ahead and leave the meeting, and then perhaps we could continue to analyze this matter, both Bernice and I, as well as the administrative law judge. As I said, those wheels are in place. Our hope is to expedite it. I'm sure that the parties and their counsel heard Mr. Walker's comments, and our hope is to see this get resolved by the parties on their own as quickly as possible.
Thank you very much. Is there any reason we shouldn't do that? Okay. It's removed from the agenda today. Back to our action items. We have an Ed Power petition for relief. Michelle McGowan, are you to address?
So as the board is aware, Ed Power has petitioned the board for relief under the contracts that are between Ed Power, the turnaround school operator assigned to operate or manage Arlington High School. In the contract between the department and Ed Power, there is language that if Ed Power does not in its judgment receive sufficient what we call little a dollars under Title I 1003 little a, it may petition the board for additional relief. If you recall, we had a joint recommendation between department staff and board staff at the June meeting, and I was a participant in all of those conversations and in that joint recommendation. So I have asked the Attorney General's office to allow one of their attorneys to advise you on resolution of this petition. And this is Gordon White, and I'll let him take it from here.
All right, thank you very much. I am Gordon White, Deputy Attorney General. I have worked with this board a little bit on and off over the years, but it's mostly been off recently, so let me introduce myself. I've been with the Attorney General's office for about 35 years. I am not an expert on education law, but over the years I've picked up some experience in the field of government contracts and process, and hopefully I can use some of that knowledge to help you through this issue. Michelle's kind of summarized where you folks are. Last month on June 3rd, the board decided to reduce SIG funding to 2 special management teams. I think I reduced it about 15%, and that was for a corporation called Ed Power and another one called Charter School USA, and I believe these schools are both in Indianapolis, or all those schools are in Indianapolis. The board has contracts with both of those corporations, and this is kind of brings us to where we are today. In both of those contracts, if the board reduces the SIG funding, the contractor can ask for relief, and that's what has happened here. The board reduced the funding last June 4th, I believe was that meeting. We've gotten correspondence from CUSA and Ed Power asking for relief. To summarize, and I'm sure you've seen these letters, they basically say you've reduced my funding. The relief I'm seeking is to have that funding reinstated. Contract that we've agreed to and that they have agreed to said that they can ask for that relief when their funding is reduced, and that kind of brings us here to where we are today. The question is, how do we deal with that request? I'm not here to help you answer the substance of that, but how do we deal with that request? I know Michelle has prepared a memo for you kind of outlining what she thinks would be an efficient way to accomplish that fact. Essentially appoint a hearing judge or well, not an administrative law judge, but a hearing examiner of some kind to hear what these contractors have to say, hear what staff has to say, and then come up with a recommendation for the board. And I believe that the target for making that recommendation would be early August, which I believe is your next meeting. So anyway, like I say, I'm here to kind of help you with that. Michelle's very involved in that decision. That's why she asked me to kind of help get this process moving along. The only problem that I think Michelle is going to help me with, I think she suggested in the memo that General Counsel, which I guess is me right now, will appoint a hearing officer, but I'm going to need a little help with that because I'm not that familiar with who you use as hearing officers and who would have the best knowledge base to help make a decision of that nature. So that's where we are. We have a suggestion from staff as to how to proceed. It seems like a sensible and efficient suggestion to me. But I think at this point, you know, if you want to ask me any questions, you're more than welcome to. But right now, we need to decide what step do we take next? What process do we use? And we have a suggestion from Michelle, which I would endorse. And I think that's where we are. So I'll let you ask any questions if you have any questions.
I just have a quick question.
ma'am.
I guess it's kind of simple. Why couldn't the process just be we vote?
I'm sorry, ma'am?
Why couldn't the process just be we vote as a board?
Well, I guess I'm not understanding the question that well. but-
Why are we wanting, what's the need of actually putting in a process to hear the petition?
Because we've agreed to it.
Why can't we just,
We've
we've
signed-
agreed to have a process to hear the petition? They've presented a petition. I guess my simple question is, why can't the board just vote? We've received the petition.
Well, if you are of the opinion that they have given as thoughtful a petition as possible, and if you have given as thoughtful a response as possible, yes, that the contract provides that you consider their request for relief, but that's all it says. But like I
Okay.
said, the question, and that's a good one now that I understand it, is what is that process going to be? Could it be something that you decide as a group? And yes, the answer is yes.
Okay. David?
My concern is for the students that they receive a continuing education, so I have a contractual question. Certainly, they have the right to petition us, as they are planning to do either today or another day. If their petition is denied, contractually, are they still obligated to fulfill the remainder of the contract, which would be the educational component for these students?
Well, and that is an excellent question. And all I can do is read back to the contract language, which I think is in your agenda packet. It says, in the event that the State Board of Education does not grant the requested relief, the TSO contractor may terminate the contract. And I believe that the time frame is within 60 days.
My other question deals with the other vendor that's affected by this, which is Charter USA. Has Charter USA come forward to petition it, or have they found other remedies to deal with the decision?
I'm not familiar with other remedies, but I do know that Charter has submitted a letter. It's a shorter letter, but the request for the relief is the same. That contract language is in both contracts with Charter and Ed Power. So that's the avenue they have decided to take. What other avenues I'm not familiar with.
So
They've
they
both-
have
both
or
chosen the
have
same-
not petitioned
I'm
for an
sorry?
appeal? They have or have not
They have,
petitioned? They
yes.
have appealed.
Yes, yes. It's a shorter letter, but it's the same request, yes.
Michelle McGowan, I guess there is some confusion over Charter USA as to whether the petition was withdrawn after it was submitted. Was it withdrawn in any matter? Okay. But the only item, the reason I asked that question is because the State Board of Ed staff only put Ed Power petition for relief on here,
Right.
but then included in the materials both. So I was kind of making an
Right.
assumption that one was withdrawn.
Sure. So my understanding is that counsel for CSUSA requested to our executive director, Bob Guffin, that we not hear or consider their petition until August. And I don't know the rationale or any information
Oh.
about that, but that's why only Ed Power is listed as an action item.
You'll forgive me, I was not aware of that.
But,
Yeah, but they both sit in letters.
And if I could, I mean, we, if the board were to adopt process, rather than just taking action on the petition, like, those are two different matters, right? So, if you choose to adopt a process, that would be a generally applicable process that for all such petitions that are sent to the board. And it would obviously apply to both, and would be utilized. Now, if the board's making decisions on the petition, then that's what Gordon's here to talk about. You know, here is your buffet of options. Please make a selection on how you're going to hear such petitions, and then you would follow that process and take action whenever that process includes you taking action. If that makes sense. Okay.
Superintendent.
Dan?
Putting a lot of pressure on me promising up a buffet.
Dan?
Maybe one or two, but not a buffet.
And it's close to lunchtime.
Yeah, really, there's only food time.
There'll be tenderloin as one option.
All right, I'll make a note of that.
Given the importance of the school being staffed, schedules, new students, I think we better deal with this issue today and make it clear what we can and cannot do, and understand from Mr. Robinson and all involved, because this isn't something you can delay and leave these students and their parents, you know, in a state of not knowing. So that'd be my concern, that we get on with this as a board. Sarah? I think you're-
Yeah, well, so sorry, Sari?
I was just going to ask the same question again. What is the start date for IPS schools? What type of window
I
are we looking
believe it's
for?
August 4.
It is August 4th as
Yep.
well.
And how about Arlington? Does anybody know?
Andrea?
If we were to follow the recommended hearing procedure and the Ed Power and Charter Schools USA were to get an unfavorable ruling, does that give them permission at that point to walk out and say school's already started, leave the school without operators?
That's what the contract provides for termination within 60 days. Now,
They could do that today, right?
Well, now that
What was the question?
I'm not as familiar with the contract.
They could
to
do
be
it
able to answer
today.
that question. I'm just kind of
Couldn't they?
focusing on this part of it.
Because
So
they've
I don't know
already,
if they could
the
walk out
ruling's
today.
already, the funding's been cut.
So Michelle McGowan, we have some questions. So number one,
Couldn't they technically terminate their contracts today?
60 days?
So I read the contract, and the contract lives with the department, so we have department counsel here, but I'm familiar with it, and it provides that they may petition for relief. If the state board does not provide such release, then they may terminate. So I'm giving that as background. If you were to select the option of just voting on the petitions today, then if that vote did not include the sought relief, then theoretically they could terminate the contracts unless the department wanted to try to challenge it, or we wanted to. But obviously there are some policy concerns of trying to.
Troy, and then Andrea.
My question has to do with, would accepting the procedures help us save time in the future? I mean, as far as this goes, because then there are steps in place, and then due process has been followed. And if we vote on it today, will they have recourse to come back and go through this process again?
Well, I think that's a very good question. And I know you've considered this question at your meeting when you decided to make this decision. And the letters say what they say, but intuitively one would think that they might have a more thoughtful, if they had more time, presentation to make. And I'm assuming that staff might also, with the benefit of a little time, have a thoughtful response. And your hearing officer, if I can use that term for sake of conversation, would have an opportunity to consider that, distill it, and present it to you, at your next meeting. And of course, you could use that process in this situation. I don't know how many contracts are like this, but you could use it here and use it in the future. It's a good model. But like I said, this is all kind of new to us, including myself.
Before Andrea, if you don't mind. So what do you see with this process as being the timeline?
Well, like Michelle is.
I mean, how long would this take to get this going?
I think Michelle's goal was by August 6th.
Which is after the start of school.
I'm not going to deny that the proposed process obviously takes time. I always like generally applicable rules that we apply consistently, and that is what led me to propose that we develop a process that would and formally adopt it and then follow that process if future such petitions were to be sent to the board. You don't have to, you certainly don't have to take it, and that's why I had asked for Gordon to be here. He has, as he described, many years of experience dealing with governance matters. But yeah, undeniably, it would take some time because it does involve a hearing officer bringing to the board a recommended decision. Now, as with the Gary School Corporation matter, it doesn't mean that the board couldn't have an emergency meeting. I know we have lots of meetings, but I am not trying to extend it. I just wanted to propose some kind of clear, transparent, objective process that could be consistently followed to address these sorts of matters.
But we could do both. We could rule on the matter today, and then moving forward, here's the process we're going to use.
Sure, and I would assume, I'll let Gordon weigh in, I would assume that you could say, we don't want this process. Our process is you come to the board and we take a majority vote. And that's our transparent, objective process that will be consistently applied. I just wanted to propose something, and I wanted to pattern it off of a similar process that exists in front of the board.
All right, Andrea, and then Sarah, then Dan.
I would like the opportunity to have a more thoughtful process to consider their request for relief. I think our priority is to make sure these schools succeed in the long term. But before we would defer a decision, I would like some kind of guarantee from the parties that they're not going to, in August or October or December, pack up and leave. So is it possible to have that conversation with the parties to see if we do a more thoughtful, deliberative process, we could get some guarantees?
Bernice, pardon me, I think Bernice wants to weigh in. General counsel for the department.
Gordon's question, just real quick, and it might help with Andrea's question. The contract, you said they could terminate today, theoretically, and I just wanted to share the specific contract language. So looking at page 7 of the contract, subsection D, it says TSO contractor termination for funding. If you look at the very last sentence, it says, in the event the SBOE does not grant the requested relief, the TSO contractor may terminate the contract. Such termination shall be effective not earlier than 60 days after written notice to IDOE from TSO pursuant to, and it gives a citation. So I just wanted to give those
Andrea, did you get your question answered?
No.
Okay.
No, and perhaps my question would have to be directed to the operators. I don't, are they going to speak eventually?
Well, the contract's pretty clear concerning their rights.
But the contract doesn't speak to whether they could make some additional agreement to conditions we might set depending on what the process is going forward.
Well, I'm not sure about that. And let's back up a couple of steps and take another look at this. The parties
Could you
have
speak
agreed.
into the mic more clearly? Speak into the microphone.
I'm sorry.
Thank you.
I've said the parties have agreed contractually to, first you make a decision. They're not satisfied with the decision, they can ask for relief. We promised that we would consider their request for relief and give them an answer. And like I say, the question we're dealing with, how do we do that? We could, look at it on paper, and we have it on paper in front of us today. I don't know that these parties have submitted anything other than their letters. And could you vote on it today? I don't see why not. I mean, the contract says consider their request for relief. You consider it, and then you do whatever you think is best. And then what happens next, as we've read in the contract, they don't have to, but they may terminate the contract. And as Bernice points out, they have to give you 60 days notice to do that. So that's kind of where we are. And like I said, the question is still the same, or the one that I'm trying to help with, maybe not very successfully, is how do you make that decision?
Okay,
Their
so
notice. Oh.
It was Andrea, Sarah, Dan, David. Sarah? Use my classroom work here.
Just a comment, but I mean, we're really stuck between a rock and a hard place, because if we go with the option where we have the hearing officer, we've got a scenario where we are potentially abandoning hundreds of students midway or after the start of a school year. However, if we have a vote today, personally, I don't have enough information here to make an educated decision on whether or not they have the appropriate funding to do their job, or what extra money would be needed, or any options on that level. So either way, I don't really see a great option, but my thought is if we can have some way to get that information, albeit having another meeting, obviously that's not preferred, but I want to do whatever we have to do to make sure that these kids are not starting the school year and then having a drastic change
Okay,
to
so,
their
so
program.
my board council just came up and said that perhaps we want to call up Ed Powers' council to address your two questions about when does the clock start to actually close doors if they wished.
All I was gonna ask is, have they provided notice to terminate as of today? Correct me if I'm wrong, but they haven't.
Can we have board counsel for the Ed Power perhaps shed some light on the questions? Okay. Wait just a moment.
That is.
Looks like we've got some. Is that okay?
I have a
Is what okay?
I
I'm
was,
sorry, I thought
I
I
was
heard
gonna
something.
call,
Well, I thought Tony was making a comment. and I-
oh,
Okay.
well,
All
yeah,
right.
he said when it's time for him.
Oh, okay, all right.
So,
Before we call people up, I'd rather have the board members speak, because there's some
Okay.
context we want to provide.
Yeah, I agree.
Yeah, we need to have our discussion, then we could call people up.
and I'm not sure we're all on the same page with this.
Well,
I
that's
think
why we need
all
to
have-
make our
I
comments.
think we all have different pieces of information, unfortunately.
Okay, well, let's have our comments.
So Sarah's wanting more information.
I don't feel we have enough right now
Correct.
to take a vote.
All right, so that's your comment.
I have a,
And
I have
now,
a
it- and
question.
now Dan, and then David, and then Tony. Dan?
David, were you ahead of me?
No.
No, Dan, go ahead.
just wanna have-
You were next.
I appreciate the theory here and how we might practice. I'm a practitioner, and I want to see what we're going to do with the young people. And so eventually we get done making our comments. I think it's very important that the board ask the operator to come up. I don't, practically speaking, I don't know where the funds are. We allocated the SIG money. We reduced it a small percent, and I believe, in light of my memory, those SIG funds weren't gonna be forever. So unless someone has a brilliant idea around that, I think the SIG funding is gonna stay the same. Otherwise, we'd have to take from other people, and that won't happen. So at that point, then I wanna know what is in place to serve these students well. Because we don't really have time at that point, if things are not in place, and contracts with teachers aren't made, and returning teachers aren't there, and master schedule's not made, and on and on and on, opening meeting with parents and students and new students and all these kind of things. If that is not in place and moving forward, then I can't stand around and watch a elongated process while young people suffer. So at that point, you have to determine if you're gonna take the students to another school, you're gonna bring another operator, what all options are there, but we can't elongate this. So today we have to get as much information, you'll never have all of it, as we can get, because I think the first determination we will have to make as a board, are there other SIG monies around? I don't think there are. If someone has them, that's super, and then how do we want to distribute them? And then if there aren't, I need to know from the operator, are they ready to operate? I have to know that as a board member, because we have responsibility over this school. So I appreciate process, and we might use it, and we might even, and we're gonna have a committee and a task force look at takeovers in the future, but as we're learning something about writing contracts. You'd need 60 days notice from April 1st, if they're gonna, or some other date. You can't have 60 days notice in June, certainly not July. And so I feel a big need to, I understand the framework, and someday we ought to have a better process and better contracts. But right now, I think there's 300 and some students that need action. Thank you.
David?
Dan just made my first point, which is obviously the department's contract needs to be revised where we get at least a year's notice of that, and I'm sure staff will work together to accomplish that. I understand that if we deny the petition, it gives them the opportunity, them being at power, to terminate the contract. Is
Yes.
that correct? Okay.
Yes, sir.
And my question is, if we don't take a vote on denying their petition or approving their petition, they are still bound by that contract. Is that correct? So my approach is
I
that
think there
by
may be a difference of opinion with that.
fine, we can vote on it, but one way to
No.
maybe accomplish this is if the triggering mechanism is our denial of their request, then I would ask us to consider to not vote on their request, and then they'd be legally obligated to continue the contract. Is that at least a plausible legal strategy?
I would say no,
Why not?
because,
Because the contract doesn't call for a timeline in which we must make a decision on their petition. Is that correct?
That is correct.
Okay,
That's
so
absolutely-
if there's no timeline, it's possible that, that this could be delayed in order to have the information, in order to hear from people.
Well, you used the word delay, and I don't know how long we're talking about delaying. Your theoretical question was.
Probably until April, to the end of the 60 days to get to the end of the school year.
You're way ahead of me on knowledge about education. and
To-
budgeting and
Tony,
stuff
I
like
think
that.
you wanted to make a comment.
I'm sorry, ma'am?
Tony Walker?
Yes, yes. They've already given us a 60-day notice to terminate the contract, right?
I don't
No,
think
sir.
so.
They just
No,
want
sir, all they've
relief
done
on
is ask
sick.
for relief
They
at this
petitioned
point.
for relief.
So they never actually gave us, okay, I thought I saw a letter where they had given us the notice. My question is, who do we have staff, either SBE or DOE, that monitors that school?
What's your question, Tony?
Do we have any staff who's responsible for monitoring the turnaround school?
Oh, certainly, we have, well,
In East Chicago?
we have,
Sorry, in Indianapolis.
oh, certainly, we have the mayor's office who oversees the schools, and we have regular reports, and we have outreach who works with the mayor's office in regards to oversight. So yes, we have an entire mechanism. Do you need them to speak?
But the mayor's office isn't doing oversight for this school, correct?
Yes, they
Yeah,
are.
they are, yeah.
We voted on it.
They are.
Okay. All right, well, can we request that maybe whoever's responsible for the monitoring, go out and actually do an independent evaluation of their readiness to go into the next school year and report back to us?
Say that again, Tony? Sorry.
Can we have whoever's responsible for monitoring that school to go out there, pretty quickly and try to do an independent assessment as to whether or not the operator is actually prepared, or what the effects are given the budget cuts, and whether or not they're prepared to open up in August or September?
You're asking if there's been meetings already? I believe there have been meetings already.
Yeah, I want some type of independent verification of what they're saying. I mean, they're telling us something, but why can't we send someone out there and actually, look at the book, so to speak?
Well, and presumably that would be discovered during a hearing process as well.
Well, I'm saying before we even entertain their petition. I mean, we're entitled, this is part of just the general oversight and monitoring of the contract period, not pursuant to their petition for relief, but, for our own best interest to make sure that if they're ready to open up, we need someone to go out and evaluate the situation.
Gordon?
Just to answer, or just to address what David raised, I don't think we have an unlimited amount of time to delay a petition for relief. I think there's probably a reasonableness factor in there in order, because it does say that in the event SBOE does not grant the requested relief. I don't think that's a license for us to not consider the petition. But I do agree that we do have the opportunity, I think, to push this off, and I personally would support a more thorough hearing process that might include as well the mayor's office and their input as part of that.
Sarah?
I was just going to ask, within their letter, they state that they would appreciate a response no later than 5 p.m. Friday, June 6th, 2014. Is there any legal standing on that date? Obviously, that's what they were requesting, but in terms of the contract wording,
No, and I'm not sure if that might have been a response to the letter. I'm not sure if that's what they were talking about as far as a response is concerned. But, here again, to get back to Dave's question, there are no timeframes in the contract, but to get back to Gordon's point, there's kind of a reasonableness standard. They ask, we need to respond. We respond, and then we see what happens. But timeframes, no, there are no specific timeframes. And yes, they did ask for a response by a certain date. That might have been a response to the letter. I'm not sure. I'm not sure if they meant response to the letter or, this kind of global response about whether or not you're going to grant them relief. I just don't.
Well, we could go through a thoughtful, comprehensive process. This is not an easy decision. Is that correct?
Absolutely, it's not. Yes.
I would not support making a decision today without the data. And so it's going to take some time. I'd like the mayor's office, who's been terrific, involved in this process to provide some information. So we're trying to get multiple indicators of what's happening.
Yes, sir.
So I think we've pretty much exhausted the questions. So do we have a motion to approve the recommended process for petition under special management teams contracts?
I'll make that motion.
Do
I'll
we,
second it.
any more discussion?
There's more discussion.
Okay.
Theoretically, this is the way to go. Take the time, do the analysis. We have the operator here. But we're not living in a world of theory. We're living in a world of 300-some students who are going to start school soon. And I want to know there's going to be someone operating that school at a high standard. And I'm a little concerned we don't have that on the table here. We're living in a convenient world where we're going to have hearing officers and pry into this and send folks out, have a lot of discussion. I think the operator needs to know, and if there's somebody with a good idea on that, maybe we put in the table in the discussion part, are there more funds available? And if there are, then where do we get them? And the other operators will probably ask for more money as well.
And Dan, I've just
So-
received information regarding that we cannot distribute any SIG funds to schools who think they're getting SIG funds until this matter is resolved.
Yeah. So that needs to be on the table and clear to them and to us, because really their relief is wanting more money. And if we know that one way or the other, that it is not possible, then we can make that decision pretty easily. It won't be easy for the people receiving that answer probably, but that would be an important piece of information. Then I want to know, as quickly as possible, starting today, are these students going to be properly served? And if not, what's plan B, and let's execute in a hurry.
So, Dan, I just want to clarify. Are you suggesting something a little different? Are you suggesting that we go ahead and make the ruling on the funding and then have a process to work with the contractor?
Superintendent, I just think that needs to be clear. And I haven't heard anybody say we can do something different on the funding, and I'd like to have that discussion. And if you'd hold that motion a minute, because I think that's an important piece of information for everybody involved and a decision we can make and should make. And then I'd like to pry open, how are these students going to be cared for then, and what their response is going to be to that.
So, okay, Sarah?
I just want to make sure I'm understanding clearly. So if we were to go back and increase funding to these two operators, that means that we would also be going back to anyone who was notified they were receiving SIG funds, and we would be changing what they have currently been
You are
told they're
correct.
getting.
You are correct.
So it's not just changing what
it
we're
is-
giving these to,
it
it's
is not.
impacting everyone.
It is not, and we
Everybody
can,
gets
and we
to move.
cannot distribute monies until this matter is
So
resolved.
everything's held up as well.
So we have a motion to institute the process to determine the petition of funding.
Should we, in the discussion phase, should we withdraw that and discuss the money first and then come back to that?
I think we can discuss the money. I mean, we're in discussion, so we can discuss
Right.
whatever.
Yeah,
we
we're in
want to
discussion of the
change
motion.
You know, and I respect what you're saying, Dan, and I respect the concerns about, you know, about the children and everything, but I do think that this process has been set up in a thoughtful way, and I think it's, for me, it's the right course forward. It's more deliberate, it takes more time, but I just want to make sure we're not overlooking anything before we take final action.
Quick comment.
Yes, is that Brad?
Yes, it is.
Okay.
I just want to echo what Gordon just said. To me, it seems like we ought to just take what's in front of us right now. And the most pressing thing is we do not have a clearly delineated process. We've got a motion to act on one here. That seems reasonable to me. I guess the comment I wanted to make is I know we've talked about a task force looking at this whole issue. I would hope that task force could also look at this particular contract language that's created this situation. It seems problematic. I'm not even really sure I understand fully why that language was crafted and put in there that way. I'm sure there's a rational reason, but I would love for somebody to take a look at that. But I'd rather us deal with just with the motion today, put a process in place, and our response back to them is that we've formalized a process and you have an opportunity to make your case, and we'll take it under advisement.
Any more discussion? Call the roll.
Mr. Albert?
Yes.
Mr. Elstrom?
No.
Dr. Freitas?
Yes.
Mr. Hendry?
Yes.
Ms. Neal?
Yes.
Mrs. O'Brien?
Yes.
Dr. Oliver?
Yes.
Mr. Walker?
No.
Mr. Watts?
Yes.
Superintendent Ritz?
No. The motion carries to begin the process, and I would hope that the process is going to be urgent and expedited.
Yes, ma'am.
Thank you. Thank you,
Thank you
Mr.
very
White. We're going to deal with one more issue and then take a half-hour lunch break. The next item is high school graduation waiver rate determination as required by HEA 1005. And Steve Baker, I believe, on behalf of the Indiana Association of School Principals, you are wanting to address the body.
Thank you, Superintendent Ritz. My name is Steve Baker. I'm principal at Bluffton High School in Bluffton, Indiana for the past 15 years. I'm also on the executive board of Indiana Association of School Principals, and thank you for allowing me to share information with you. IASP was asked to assist in the survey that I believe Michelle Walker will be sharing with you. I don't know all of the results, but I believe the recommendation that Mrs. Walker will be making to you is consistent with what I'm hearing from high school principals all over the state, and that is the 10% over 3 consecutive years is a fair number for students, fair number for schools, especially that the groups of students like special needs students, other students who have difficulty with high-stake assessments will be included in that 10%. We also like the idea that the schools will be working with the Indiana Department of Ed and to address the concern and to try to create a solution. We believe that that is a good approach with this. The overall point we feel is to address and help schools with large waiver percentages. We know that's a concern, and we believe that this recommendation will help meet that goal. Assisting versus punishing is always a better route. Troy Albert made a statement a few meetings ago about if a student meets the all the waiver requirements, and that student should be granted the waiver. If you've looked at the waiver, it is a very comprehensive and extensive requirement that a student must meet. I believe in that as well as a high school principal. Many of my students, last year, and I don't quote me on this, but I think Bluffton High School is around 6%, plus or minus a percent for waivers. And I can tell you those students who are granted waivers are very productive citizens of our community. Had I had a cap or made those waiver requirements more stringent, those students would not have received a diploma and would not have the opportunities that they have been given. And again, they're doing very well. So ISP is in supportive of this recommendation, and thank you for taking it under advisement.
Thank you. You have the information before you. We've had several times of discussion on this very topic. I move to require that schools with a percent of graduation waivers exceeding 10% each year for 3 consecutive years, however, excluding students for whom the case conference committee has determined waiver appropriate, to establish a school-wide remediation plan as recommended by the department. I have Michelle available if you have questions. David.
Hi, Michelle.
Oh, wait, is there a second? Am I so sorry?
Second.
Okay, now discussion.
Michelle, I have a question about the 3 consecutive years. I've received some input from people that said it should be every year, not 3 consecutive, because you could do 2 years going beyond it. You could have 50% waiver, and then that 3rd year, you're at 10%. And so I've received some constituent comments about that possibility. So could you talk about the rationale for having 3 consecutive versus annually or 2 consecutive years?
Absolutely. So I just distributed a handout that basically summarizes everything we've been talking about with regard to this topic over the last few months. That information is on these slides as well, so it's really no different from the slide deck, so I didn't give you a copy of that. But what I wanted to, excuse me, here. I want to get to the slide that shows what you're asking about, Dr. Freitas. One of the concerns that was raised from the field, and maybe you heard this as well, is shouldn't we be looking for a pattern of concern with regard to this? So the legislature has clearly delineated what the requirements or the criteria are for a waiver. The State Board of Education, your responsibility is to determine really what percent is the appropriate amount that would necessitate the remediation plan. And so one of the things that, again, we heard from the field, and when we discussed this within our own, the Department of Education staff, looking for a pattern for a school is probably something that I think Steve Baker would say is assisting the school rather than punishing the school. On this slide and on your handout, there's the percent of schools who actually would be required to develop the remediation plan had we done a single year piece of data. So to the question that was raised by your constituents, that's the top table on this slide. That's on the reverse side of your handout. Pardon me. So a third, actually more than a third of the schools would actually be required to, if over the last 3 years we used a single year, would be required to create the remediation plan. One of the things we also prepared for you in the last few months is what if it was a 2-year pattern? And so that's the next particular graphic on your handout. And that goes down, it's about a quarter of the schools. But I think what we're hearing, especially from the survey as well, is we want to make sure that we're being fair and looking for that pattern of concern and giving assistance. One of the things that you had asked us to do was look at the special education data, and that's on your handout as well. Let me see if I can get back here. And when we looked at both all waiver data and special education data, all of the statewide averages were less than 10%. And you might remember when we first started talking about this, we had some, is it 10, is it 15, is there a magic number? And so we actually looked at lots of data to try to inform your decision. So this is just kind of revisiting, again, all waivers, statewide average, has been for the last 3 years less than 10%. Special ed waivers are about, well, you can see a little over 3%. The other thing that was raised by this group was schools that have poverty, a high poverty level. And so we did look at that as well. So it's about a quarter at the most of the schools with greater than 10% are actually in the high poverty category. And this may be too much information for you to make your decision, but as a result of all of the things that you have been looking at in the last few months, and looking at the results of the survey, which was really asking the field about students with IEPs, and also Becky Bowman, who's our Director of Special Education, she weighed in. And really, because the criteria for a waiver is not different for students with disabilities, she was really overwhelmingly agreeing with those on the survey, and it was about a half and half mix, who indicated really those students are expected to master the content as well. And so therefore they should be part of the calculation, especially since it was just a little over 3%. So the recommendation that we've made for you, and again, you can certainly change this recommendation, but is that we would look for 3 consecutive school years if a school had greater than 10% of the students receiving a waiver in the graduation class, that they would then create the remediation plan. And the first time that happens, the remediation plan is created by the school and submitted to the Department of Education. And the second time, if it happens a second time, whether it's subsequent or later, then the department actually assists the school in developing a plan, and the school would revise their plan. So again, it doesn't change the waiver requirements whatsoever about the criteria for a student actually obtaining a waiver, but it is, what you're setting is what is the percent that indicates really the school does need a plan to remediate and assist those students with learning needs.
In the plan that they create, are there some commonalities in that plan? I don't think we've ever seen one of those plans, but what is sort of the proactive
That's a great question, and
strategies?
actually, the statute doesn't require any particular components
I
of the
know
plan.
that's why I'm asking.
And so one of the things that we would do is develop a draft plan for you to review and see if it meets your expectations. In terms of the types of things that we're looking for from a school. And certainly we want it to be really school-based and student need focused, but there might be a handful of requirements that the board would like to see within a plan. So we would look forward to working with you on that.
Okay, good.
Thanks.
Any more discussion? Troy?
Mr. Albert had a question.
I just want to ask, I know the principals did a survey. Can you judge, was it a good
It was about
sampling?
half and half in terms of,
I mean, was it a good sampling as
we
far
had
as large?
137 respondents, which is pretty good considering the time of year and how surveys go when you try to get folks to respond. What was helpful is the survey was about, again, should students with IEPs be included in the percentage that you're actually establishing as a board? And what was helpful is lots of comments about how the case conference committee is involved. The criteria is no different. So again, it was about half of those responding saying, yeah, let's leave them out of the mix. Let's not include them in the calculation. And the other half saying, but the requirements are the same for these students. And these are students who are working toward a diploma. So we want to count them in establishing a need if the school has a need for assistance. So we were pleased that folks took the time this summer to respond.
Thank you, Michelle.
You're welcome.
One more question, Dan?
Yeah, I have one. I want to make sure I'm crystal clear. The consequence,
Sure.
and exactly if you have a very high poverty school in a challenging area, the 10% is standard.
It is standard.
Now, I want all children, obviously, to get a diploma that means something.
Right. That was one of the questions that you as a board asked,
Yeah.
was has the poverty level actually impacted this
'Cause I
in
want it
terms
to
of
be
how the
I
number
want-
of schools?
I want to drive out so we don't have waivers, obviously, but
Right, right.
getting there,
And I think that's another reason why you as a board really were not interested in a higher number, like 30% of the students could get a waiver, or, you know.
it's like saying it's okay. It's not.
Right, and I think,
So the consequence, if you have 3 years,
is that the,
10%
go
or
ahead.
more,
is that the school, I'm sorry. Do you want me to continue?
You finish it.
Okay, I'm sorry.
The consequence is?
You're right. The consequence is that the school must create a remediation plan to address the learning needs of students who
That's
are
after
not
2 years, right?
proficient. So if they hit the 3-year threshold, they fall into the bucket of those schools that need to create the plan. The plan is, how do they actually address the learning needs of students in their school who are not proficient. In this case, it happens to be ECAs because that's how a graduation waiver is started, is by not passing one or both of those. And so it's not that the school doesn't already do remediation, but this is really drawing to the attention of the school. Really, the percent of waivers seems to be high based on the statewide average. And so what can you do as a school to address the needs of some of your students who are receiving a waiver, that maybe we could actually have them pass the test rather than receiving a waiver for the future? So that's what the consequence is. If let's say the next year they also are more than 10%, so that puts them in the second round, if you will. So the second round, and again, this is on your handout as well as in the part of the process, would be that the department is required to work with the school to revise their plan, to make it even better, to hopefully have more students proficient in terms of college and career readiness and meeting the graduation requirements. Did that answer your question?
Yeah.
Can I ask one
And
more?
Troy and then David.
I just want to restate, I really think the cohort changes a great deal depending upon the type of student that you have in there. So the 10% over 3 years is fair to if you have a high influx of special needs or functional skills kids in one cohort at that time. So it does provide that balance throughout, and you have to have a trend that shows that you are not trying to meet that standard. So I really think it gives something, and it doesn't allow, I will say it will discourage a lot of principals from cheating, and that will not happen because they have that point.
David?
I was going to make the point too about the cohorts, that these are cohorts going through.
Right.
It's 3 different cohorts,
Right.
groups of people. So that's
Right.
why I support this proposal, because you're looking at systemic school-wide
Right.
problem,
That's
if
correct.
there is one, based on different cohorts of students. So that's why I think it's a great idea to do it this way.
Okay. So,
Question?
oh, is that Tony? Okay, well, go ahead, Tony.
Yeah. Did the data that we just saw include, those numbers include special ed students?
Yes.
Yes, it does.
Okay.
So there's a motion and there's a second. Any more discussion? Roll call, please.
Mr. Albert?
Yes.
Mr. Elson?
Yes.
Dr. Freitas?
Yes.
Mr. Henry?
Yes.
Ms. O'Neill?
Yes.
Mrs. O'Brien?
Yes.
Dr. Oliver?
Yes.
Mr. Walker?
Yes.
Mr. Watts?
Yes.
Superintendent Ritz?
Yes. The motion carries. We are going to be recessed until 1 o'clock. Thank you very much.